Hello, my name is Maria Lazar. I am a Court of Appeals judge on District 2. I just started last August. Before that, I was 7 years on the trial court in Waukesha. So the panel I was on winning techniques and how to make the record to win or prevail on appeal. And it's very important because the appellate courts can only see what's in the record. So we're trying to advise attorneys on what to do to make sure they get a good record and improve their odds or chances on appeal. So what you have to do when you're making the record, you're the attorney, you have to make sure your record is clear. You don't want your witnesses to say things like this far or that side. And if they do say that, you want to interrupt them and say, are you saying 2 feet away? Are you saying the left-hand corner? You have to make the record clear because when it goes up to the Court of Appeals, it's black and white. It's just the words. There are no hand gestures and there's nothing else. So you have to make sure you're keeping your eye on that record. So what I meant by making your record is to make sure that you're keeping track that all your exhibits that you're introducing, that they get admitted into evidence, because I've seen several times on appeal and in the circuit court where the attorneys forget to move their exhibits into evidence, and then they're not there, the witness leaves, you can't do a foundation with it, and you're going to lose an important piece that you need when you're on appeal. The third point that I raised was to stay on the record. And this is going to be difficult and interesting in that you may have a trial court judge, who doesn't do things on the record. They won't do their sidebars on the record. They don't do their jury instruction conferences on the record. They do them maybe in chambers. They do them maybe on the side. That's not recorded by the court reporter. So the first thing you want to do is try to stay on the record. If you're not on the record, when you go back on the record, the trial court is going to summarize what happens. You have to be listening very carefully, because if you've made an objection, if you've done something that's not covered by what the trial court summarizes, you have to respectfully put that into the record, because otherwise you've waived that objection or you've forfeited it. So when you get on appeal, you can say, when you were in the judge's chambers doing the argument on jury instructions, you raised this objection, but you didn't say it when it was back on the record. And the Court of Appeals is going to say, it's not in the record, it's not there, we're not going to look at it. So if there's a gap in the record, if the judge has made a ruling and you don't think the ruling covers everything that's in front of you, it's your obligation, it's your responsibility, and it's very important that you raise that to the court. Judges should not be offended that you're doing that. If they do get offended, you still have to make your record, and you still have to say, Your Honor, you ruled on the first part of my motion, you granted it, but you didn't say anything about the second party. Are you granting it for them as well? And if you don't do that, you're going to have to file a motion for reconsideration, a motion for clarification, or when it goes up on appeal, it's so muddied up that you're just not going to prevail. So you shouldn't offend the judge, and if you do, I'm sorry, you still have to make your record and you still have to say it.